Citizens were forbidden from eating certain imported delicacies during specific periods, ostensibly to preserve Roman moral character, but actually to maintain economic controls that benefited particular merchant classes. The Lex Fania regulated not only what could be eaten at dinner parties, but how much hosts could spend, how many guests could attend, and what entertainment could be provided. Violations were monitored by informants who attended social gatherings specifically to report illegal luxury to authorities. The law created a bizarre situation where Roman citizens had to calculate the legal value of their meals, measuring portions and counting courses to avoid accidentally crossing thresholds that could result in massive fines or imprisonment. Even more absurd were regulations governing the consumption of wine. Certain vintages were reserved for specific social classes, and drinking above one's station could be interpreted as political sedition. The laws extended to musical entertainment, with restrictions on which instruments could be played at private gatherings and which songs could be performed. Citizens lived in fear of their own dinner parties, where a miscalculation in menu planning or an overly enthusiastic musical performance could lead to criminal charges. The Lex Scantinia, though poorly documented in its specific provisions, appears to have regulated sexual behavior with a vindictiveness that defied both logic and human nature. The law criminalized certain sexual acts between free citizens while apparently permitting the same behaviors with slaves, creating a legal framework that transformed sexual preference into a marker of social status. Roman citizens could face exile, property confiscation, and social death for private consensual behavior that violated poorly defined moral standards, while the same acts committed with enslaved persons carried no penalty whatsoever. This created a system where sexuality became another tool of class oppression, where the wealthy could satisfy any desire through slave ownership, while the poor faced legal persecution for the same behaviors. The enforcement of such laws required a level of intrusion into private life that makes modern surveillance seem restrained by comparison. Informants, household slaves pressed into service as witnesses, and elaborate sting operations designed to catch citizens in compromising positions. The laws regulating gladiatorial games reveal Roman legal thinking at perhaps its most contradictory and cruel. While gladiatorial combat was celebrated as the pinnacle of Roman entertainment, the laws governing these spectacles created impossible situations for both participants and spectators. Gladiators themselves existed in a legal limbo. Technically free men who had voluntarily entered servitude, they could be executed for refusing to fight, but also faced criminal charges if they displayed insufficient enthusiasm for their own potential death. Spectators were regulated with equal absurdity. Cheering for the wrong gladiator could be interpreted as political sedition, while failing to show sufficient enthusiasm for imperial favorites could result in accusations of disloyalty. The laws governing betting on gladiatorial outcomes were so complex that citizens needed legal experts to place wagers without risking criminal charges. And the wrong bet placed on the wrong gladiator at the wrong time could be interpreted as everything from tax evasion to treason. Training schools for gladiators operated under regulations that required them to produce fighters willing to die entertainingly, while simultaneously forbidding any training that might actually prepare men for survival, creating institutions dedicated to the production of beautiful corpses for public consumption. The laws governing slavery created paradoxes that defy rational comprehension, where the same legal system that granted masters absolute power over slave bodies also criminalized certain treatments of slaves while mandating others. Masters could legally torture, maim, and execute their slaves for any reason or no reason, but faced criminal charges for freeing them in ways that violated procedural requirements. Slaves could be compelled to testify against their masters only under torture, because Roman law held that slaves were incapable of truth-telling without physical coercion, yet the same legal system granted freedom to slaves who informed on their masters' illegal activities. The result was a framework where slaves lived under the constant threat of torture as a legal requirement, while masters faced criminal liability for both cruelty and mercy that violated technical regulations. Manumission laws were particularly twisted. Freeing a slave incorrectly could result in the slave remaining in bondage, while the master faced penalties for attempting illegal liberation, creating situations where kindness became criminal and cruelty was mandated by law. Roman religious laws transformed spiritual practice into another avenue for legal persecution, where worship itself could become a capital offense depending on political circumstances and imperial whims. The Lex Julia de Majestat criminalized religious practices that could be interpreted as challenges to imperial authority. But the definitions were so vague that nearly any spiritual activity could potentially violate the law. Citizens were required to participate in state religious ceremonies, while simultaneously being forbidden from religious practices that might compete with official cults, creating an impossible balance where both religious devotion and religious indifference could result in criminal charges. Christians faced particular persecution not only for their beliefs, but for their refusal to participate in state religious rituals. Yet the same laws that mandated participation also criminalized excessive enthusiasm for non-Christian religious practices. Jewish citizens existed under special regulations that simultaneously granted them exemptions from certain religious requirements, while subjecting them to heightened scrutiny for any deviation from prescribed behaviors, creating a legal framework where being too Jewish or not Jewish enough could both constitute criminal offenses. The economic laws governing trade and commerce descended into micromanagement so detailed and contradictory that conducting business became an exercise in navigating legal impossibilities. Price controls were established for hundreds of commodities, with penalties for both charging too much and charging too little, creating markets where any transaction could potentially violate regulations. The Edict on Maximum Prices, issued by Diocletian, attempted to control inflation through legal terror, mandating death penalties for merchants who exceeded prescribed prices while simultaneously criminalizing the refusal to sell goods at those same prices. Citizens were forbidden from hoarding certain commodities during shortages, but also prohibited from selling them too quickly during abundance, creating legal situations where any economic decision could be construed as criminal. Import and export regulations were so complex that merchants needed teams of legal experts to conduct international trade, and violations carried penalties that could destroy not only businesses, but entire families through property confiscation and exile. The laws governing taxation created a system where citizens were legally required to report income and assets with perfect accuracy, while being denied access to the legal standards by which their reports would be judged. Tax collection was farmed out to private contractors who were legally entitled to use any means necessary to extract payments, while simultaneously being held responsible for collecting predetermined amounts regardless of citizens' ability to pay. This created a situation where tax farmers had every incentive to extract maximum payments through legal extortion, while taxpayers had no reliable way to determine what they legally owed or how to prove they had paid correctly. Penalties for tax evasion included slavery, exile, and death, but the complexity of tax law meant that perfect compliance was virtually impossible, making every Roman citizen technically a criminal awaiting discovery. The laws governing public behavior criminalized activities so basic and universal that simply existing in public space became a constant legal risk. Citizens were forbidden from gathering in groups larger than specific numbers without permits, but the regulations governing permits were so complex and contradictory that obtaining legal permission was often impossible. Public speaking was regulated with rules that criminalized not only seditious content, but also seditious tone, gesture, and timing, making any public expression potentially treasonous. Even walking in public was subject to regulations. Certain streets were forbidden to certain classes at certain times, and violations could result in immediate arrest and punishment. Citizens were legally required to show proper deference to officials and nobility through prescribed gestures and verbal formulas, but the requirements were so elaborate and situation-specific that mistakes were inevitable and carried severe penalties. The laws governing inheritance created situations where death itself became a legal minefield for survivors, where grief had to be balanced against complex bureaucratic requirements that could invalidate bequests and destroy families. Wills were required to follow precise formulas and include specific language, But the requirements changed frequently and were applied retroactively, making documents that were legal when written potentially criminal when executed. Heirs were responsible not only for inheriting assets, but also for inheriting the legal liabilities of the deceased, including debts and criminal charges, creating situations where receiving an inheritance could result in immediate imprisonment or execution. The laws governing funeral expenses were so detailed that families had to calculate the legal cost of grief, measuring everything from the price of flowers to the wages of mourners, to ensure compliance with regulations that seemed designed more to torment the bereaved than to serve any rational legal purpose. Throughout all these legal absurdities ran a common thread of vindictive control, where laws existed not to create justice or maintain order, but to remind citizens that their lives were entirely subject to the whims of power. The complexity and contradictions were not accidents, but features designed to ensure that every citizen was technically in violation of some law at all times, creating a population that lived in constant fear and dependence on the mercy of officials who could selectively enforce regulations for political or personal benefit. The Roman legal system became a weapon wielded against its own citizens, a tool for maintaining authority through the constant threat of arbitrary punishment, disguised as the rule of law. The psychological impact of living under such regulations cannot be overstated. Imagine waking each morning knowing that your clothing, your food, your words, your gestures, your religious practices, your economic activities, and even your emotional expressions were all subject to legal scrutiny by officials who had every incentive to find violations and no accountability for the consequences of their decisions. Roman citizens developed a hyper-vigilant relationship with law that perverted the very concept of justice, where legal compliance became not a matter of avoiding harm to others, but of performing submission to authority through the precise choreography of daily life. These laws were not merely historical curiosities, but instruments of systematic oppression that reveal how legal systems can be transformed into mechanisms for the exercise of arbitrary power, where complexity serves tyranny and absurdity becomes a tool of control. The legacy of Roman legal absurdity echoes through history in every legal system that prioritizes the convenience of authority over the rights of citizens, in every regulation that criminalizes normal human behavior for the purpose of creating a compliant population, in every law that exists not to protect but to punish, not to clarify but to confuse, not to serve justice but to demonstrate power. As you consider these forgotten laws from the shadow of the eternal city, ask yourself, how different are the absurdities of Roman law from the regulatory complexities that govern your own life? Do you live free from legal systems that criminalize normal behavior, that demand impossible compliance, that exist more to control than to protect? The Romans believed they were creating eternal laws for an eternal empire, yet their legal legacy is one of caution about the dangers of unchecked authority and the human capacity for transforming justice into tyranny through the simple expedient of making law too complex for citizens to understand or follow. If this journey through the legal labyrinth of ancient Rome has revealed truths that resonate in your own time, share your thoughts. Subscribe for more explorations into the dark machinery of power disguised as law, and remember that the price of freedom is eternal vigilance against those who would use legal complexity to disguise the simple desire to control. Would you have survived as a citizen of Rome, navigating the impossible maze of absurd laws that could destroy lives for the crime of living normally? Or do you recognize in these ancient absurdities the echo of contemporary legal systems that serve power more faithfully than they serve justice? Imagine walking through the bustling streets of ancient Rome, past marble columns and crowded forums, unaware that your every step could be leading you toward a violation so bizarre, so utterly incomprehensible, that modern minds struggle to accept these laws ever existed. Picture a world where the color of your toga could sentence you to death, where eating certain foods in public marked you as a criminal, where the way you mourned your dead could result in exile or execution. This was Rome, not just the empire of gladiators and conquest we remember, but a labyrinth of legal absurdities so twisted and cruel that they reveal the darkest corners of human nature when power runs unchecked and tradition becomes tyranny. In the shadows of the Colosseum and beneath the grandeur of imperial palaces lurked a legal system that could destroy lives over the most trivial infractions, where senators debated whether a man should die for wearing the wrong shade of purple, and where laws existed not to protect citizens, but to remind them that their lives, their bodies, their very existence belonged entirely to the state. These were not merely ancient customs or quaint historical curiosities. They were instruments of terror, weapons of control, reminders that in Rome, absurdity and brutality walked hand in hand through the corridors of power. Consider the sumptuary laws, regulations so intricate and vindictive that they turned daily life into a minefield of potential capital offenses. Roman citizens were forbidden from wearing purple garments unless they held specific ranks, a law that sounds harmless until you realize that purple dye was so expensive that only the wealthy could afford it, making this legislation a tool for maintaining rigid class distinctions through the threat of execution. But the madness went deeper. Certain shades of purple were reserved for different levels of authority, creating a spectrum of death where wearing the wrong hue could be interpreted as impersonating an official or, worse, aspiring to imperial power. Citizens lived in constant fear of their wardrobes, checking and rechecking the exact shade of their clothing, knowing that a merchant's mistake in dyeing fabric could lead to accusations of treason. The law extended to jewelry, hairstyles, and even the number of rings a person could wear. Senators were limited to specific quantities of gold, while lower classes faced severe penalties for displaying any luxury beyond their station. Women faced particular scrutiny. Their dress, makeup, and accessories were regulated with obsessive detail, and violations could result not only in personal punishment, but in charges against their husbands and fathers for failing to control their households. The laws governing mourning reveal perhaps the most sadistic aspects of Roman legal thinking, transforming grief itself into a potential crime. Families were strictly limited in how long they could mourn deceased relatives. Excessive weeping was considered a disruption to public order and an affront to Roman stoicism. Professional mourners, women hired to wail and tear their clothes at funerals, were regulated by laws that specified exactly how loud they could cry, how dramatically they could gesture, and how long their performances could last. Violation of mourning regulations could result in exile for the entire family, the logic being that excessive grief suggested insufficient loyalty to Roman values of strength and endurance. The state demanded that citizens grieve according to prescribed formulas, turning the most human of emotions into a choreographed performance subject to legal scrutiny. Even more bizarre were the laws that forbade certain expressions of mourning based on the deceased's social status. Slaves and freedmen could not be mourned with the same intensity as citizens, and elaborate funerals for the wrong class of people could be interpreted as sedition. The Lex Oppia stands as one of history's most vindictive attempts to control female behavior through legal terror. This law, passed during the Second Punic War, forbade women from owning more than half an ounce of gold, wearing multicolored garments, or riding in carriages within city limits except for religious festivals. The stated purpose was wartime austerity, but the law remained in force long after the military crisis had passed, revealing its true function as a tool for suppressing female autonomy and visibility. Women who violated these regulations faced not only personal punishment, but brought shame and legal consequences upon their male relatives, creating a system where families policed their own members out of fear. The enforcement was particularly cruel. Informants were rewarded for reporting violations, turning neighborhoods into networks of surveillance where women lived under constant observation. Even attending public events became dangerous, as officials would scrutinize female attendees for signs of illegal luxury, measuring jewelry and inspecting fabric with the thoroughness of military inspectors. The law created a climate where femininity itself became suspect, where any display of beauty or wealth by women was interpreted as a challenge to male authority and Roman virtue. Roman marriage laws descended into absurdity that bordered on mathematical precision in their cruelty. The Lex Julia de Maritandis Ordinibus required men between 25 and 60, and women between 20 and 50 to be married, with specific penalties for those who remained single or childless. Bachelors faced restricted inheritance rights and were barred from receiving bequests from non-relatives, while childless couples lost portions of their inheritances to the state. The law included provisions that calculated acceptable reasons for divorce with bureaucratic precision. Adultery, of course, but also failure to produce children within specified timeframes, and even incompatibility in social rank that had not been apparent at the time of marriage. Divorced individuals were required to remarry within specific periods or face escalating penalties, creating a legal conveyor belt that pushed citizens through multiple marriages regardless of personal preference or compatibility. The state inserted itself into the most intimate aspects of human relationships, determining not only who must marry whom and when, but also regulating sexual behavior within marriage, with laws that specified acceptable practices and positions. Violations could result in exile, property confiscation, and social disgrace that extended across generations, as children of illegal unions faced lifelong disabilities under Roman law. The laws governing dining and entertainment transformed even the most basic human activities into potential capital offenses.